If you break your arm, you go to the hospital.
Right, yeah. You get an X-ray.
Exactly. You get an X-ray, and it gives you a very clean binary answer. It's either broken or it's not broken. It's just a precise physical reality.
Yes.
And generally speaking, I think we expect the American justice system to work the exact same way, right? Like a person commits a crime, the law is applied, and you get a binary result.
Guilty or not guilty.
Right. But what if the machine taking the X-ray is, well, fundamentally rigged, like rigged to show a break just because of how much money you have in your bank account?
Or, what zip code you happen to live in.
Yes, exactly. So today we're doing a deep dive into an independent legal essay by Zachary David Enfield. It's called Processed Before Protected: Equal Protection and the Unequal Machinery of American Justice.
That's a heavy one.
Oh, it is. Enfield is making this radical, sweeping argument that the American criminal justice system basically violates the constitutional promise of equal protection. And not just through individual rogue biases, I mean.
Right, he's arguing it does this through its very structural architecture.
Yeah. From the brutal math of public defender budgets to the coercion of cash bail, all the way upstream to, and this is wild, how U.S. senators are actually elected.
And before we get into the gears of this machinery, we really need to firmly establish the parameters of our discussion today.
For sure.
Because this source material, it contains some highly politically charged critiques of the U.S. government, the Supreme Court,
Yeah.
foundational legal doctrines.
A lot of settled law, basically.
Exactly. So we want to be incredibly clear with you, the listener, right up front. We are not taking sides here.
Not at all.
We aren't endorsing the left-wing or the right-wing implications of any of these viewpoints. Our sole purpose today is to just impartially report on the contents, break down the author's arguments, and, help you understand the fascinating ideas contained in the original text.
Right, we're just your guides through a very dense, very provocative essay. So let's just jump right in. Enfield starts with a foundational premise that really challenges how we view the courtroom.
He really does.
He argues that America essentially confuses minimum representation with actual equal protection. He says that a completed docket, the piece of paper showing a plea was entered, a lawyer was assigned, is really just what he calls a procedural skeleton.
It's procedural skeleton, yeah.
Right, like it records the procedure of the law, but it completely conceals the invisible structural pressures that are just crushing the defendant.
And he frames the experience of the accused in a way that modern legal doctrine deliberately avoids, honestly.
How so?
Well, the doctrine, like the way the law is currently interpreted by judges, it tends to isolate every single interaction.
Okay.
So you deal with the police, that's one constitutional test. You deal with the bail magistrate, that's another test.
Okay, right, yeah.
Prosecutor, another test. But Enfield introduces this concept he calls the whole machine principle.
The whole machine principle. Okay, let's unpack this.
He argues that the accused doesn't face separate independent offices in a vacuum. They don't face a judge on Monday, a jailer on Tuesday, a prosecutor on Wednesday.
Right, it's all happening at once.
Exactly. They face the combined cumulative force of the state all at the same time.
I want to pause on that because the state loves to compartmentalize things.
Oh, absolutely.
Like if a defendant complains the system is unfair, the judge is usually just going to say, look, your lawyer was present, the prosecutor made a legal offer, I signed the paper, every individual box was checked.
And if you look at current legal doctrine, it explicitly permits and even encourages that exact fragmentation.
So to understand Enfield's critique, we have to look at the settled law he's actually pushing back against. Right?
Yeah. We have to look at a massive Supreme Court case from 1973. It's called San Antonio Independent School District v. Rodriguez.
Okay, take us back to 1973. What actually happened in that case?
So it actually started over public school funding in Texas. The funding was tied to local property taxes.
Oh, I know where this is going.
Right, so if you lived in a wealthy neighborhood with high property values, your public school was incredibly well funded. But if you lived in a poor neighborhood, your school was drastically underfunded.
So the parents in the poor district sued.
Exactly. They sued, arguing this violated the Equal Protection Clause of the 14th Amendment. They argued that wealth, or really the lack of it, was being used to discriminate against them.
Which, makes intuitive sense. If the government is providing a service and the poor get a terrible version of it solely because they are poor, that feels completely unequal.
It does feel unequal, but the Supreme Court actually ruled against them.
Wait, really?
Yeah. The court established that wealth is not a suspect classification that triggers strict scrutiny.
Okay, time out. Suspect classification. Strict scrutiny. You just lost me in a total cloud of law school jargon.
Fair enough, fair enough.
What do those terms actually mean for a regular person listening right now?
Okay, so in constitutional law, the government discriminates all the time, and it's mostly perfectly legal.
Okay, give me an example.
Like, the government says you have to be 16 to get a driver's license. That technically discriminates against 15-year-olds.
Right.
But if you sue over it, the court uses a very low bar called rational basis. They just ask, does the government have a rational reason for this rule?
And obviously, keeping inexperienced kids off the road is rational.
Exactly.
Yeah.
So the law survives. It's legal discrimination.
Okay, so when does it actually become illegal?
When a law discriminates based on what the court calls a suspect classification, things like race, religion, or national origin.
Okay, got it.
If a law says only white people can get a driver's license, the court applies strict scrutiny. That's the highest, most difficult hurdle in constitutional law.
The government's basically going to lose that one.
Almost always, yeah.
Yeah.
So the parents in the San Antonio case, they wanted the court to treat wealth like race or religion.
Oh, I see. They wanted laws that discriminate against the poor to face strict scrutiny.
Exactly.
Yeah.
But the Supreme Court said no. Wealth is not a suspect classification. As long as the government has a rational reason, wealth disparities are perfectly legal.
That is a massive precedent. I mean, that basically gives the government a green light to run systems that completely obliterate the poor as long as they don't explicitly say they're doing it because of race or religion.
Precisely. And then just 3 years later, the Supreme Court doubled down in a case called Washington v. Davis.
What happened there?
This case involved a written personnel test that was given to police applicants in Washington, D.C. The statistics showed that black applicants failed the test at a disproportionately higher rate than white applicants.
Okay.
So the black applicants sued, arguing the test violated equal protection because of its disparate impact.
Disparate impact, meaning the actual result of the law is unequal, regardless of what the text says on paper.
Exactly. But the Supreme Court ruled that a disparate impact alone isn't enough to trigger an equal protection violation.
You're kidding.
No. They ruled you have to prove discriminatory intent. You have to prove the authors of the test actively, subjectively intended to discriminate.
So let me get this straight. If a law accidentally punishes poor people or disproportionately impacts a minority group in practice, that's completely fine under the Constitution.
Under current doctrine, yes. A system is allowed to produce radically different outcomes based on someone's wealth or geography, just as long as the law is facially neutral.
Facially neutral.
Right. Meaning the text of the law itself doesn't explicitly discriminate, and you can't somehow prove malicious intent by the lawmakers.
You know, the defender of the current system would probably say, look, we live in an unequal world. Some people have more money than others. The Constitution promises equal laws, not an equally wealthy society.
Right. They'd say you are confusing an unequal reality with an unconstitutional law.
Right. And that is the exact doctrinal wall that Enfield is attacking here, isn't it?
It is. He points out that the text of the 14th Amendment, which says no state shall deny any person within its jurisdiction the equal protection of the laws, it says absolutely nothing about equal protection being limited to facial classifications.
Right.
Or discriminatory intent. It says nothing about being satisfied by a bare procedural minimum.
So Enfield argues that doctrine can be completely settled by the courts and yet still be structurally, constitutionally, and morally wrong.
Exactly. He says the gap between the text of the Constitution and the reality of the doctrine is the indictment itself.
It's like, okay, let's use an analogy here. It's like claiming a mining corporation's safety standards are perfectly equal because every single worker is handed a plastic hard hat at the front door.
Right. The policy is facially neutral. Everyone gets a helmet.
Exactly. But then half the workers are sent to sit in a padded, climate-controlled administrative office, while the other half are sent thousands of feet underground into a structurally collapsing, unventilated mine shaft. And when the mine collapses, the state comes in, looks at the paperwork, sees that everyone signed for their helmet, and declares that the safety protections were completely equal.
Yes.
In this scenario, the helmet is the assigned public defender. But the collapsing mine is the entire machinery of the justice system surrounding that lawyer.
That analogy perfectly captures his whole machine principle. A public defender's signature on a court docket is just the helmet.
Right.
But a lawyer's name on a piece of paper does not actually protect a defendant by itself. Investigation protects. Time protects. A fair bond hearing protects.
Meaningful review protects.
Exactly. If every other part of the machinery is wildly unequal, the helmet doesn't save you from the collapsing mine.
So the public defender doesn't have time, and the system is designed to ignore the reality of wealth.
Right.
If the whole machine is what matters, I think we should examine the very first gears a defendant gets pulled through when they enter this system.
Let's do it.
Because this is really where the facade of representation meets the brutal reality of the cage.
Yeah. And to understand the floor of legal representation in America, we really have to look at the landmark Supreme Court case, Gideon v. Wainwright from 1963.
We should definitely tell the story of Clarence Earl Gideon because it so perfectly highlights the gap between the constitutional ideal and the modern reality.
For sure.
Gideon wasn't some high-profile activist. He was a poor drifter with an 8th-grade education.
Right. In 1961, Gideon was accused of breaking into a pool hall in Panama City, Florida, and stealing some change and a few bottles of wine.
Okay.
He went to court and told the judge he couldn't afford a lawyer, and he asked the court to appoint one for him. But at the time, Florida law only required appointed counsel in capital cases.
Cases involving the death penalty.
Right, so the judge just said no.
Wow. So Gideon literally had to represent himself.
He did. He tried to cross-examine witnesses, but obviously he had no legal training. He was convicted and sentenced to 5 years in prison.
And then from his prison cell, literally using prison stationery and a pencil, he wrote a petition to the United States Supreme Court.
Just incredible.
He argued that his trial was fundamentally unfair because he didn't have a lawyer.
And in a really rare move, the Supreme Court actually took the case. They appointed a powerhouse lawyer, Abe Fortas, who would later become a Supreme Court justice himself, to argue for Gideon.
And the court ruled unanimously in his favor.
Unanimously, yes. They established that the Sixth Amendment right to counsel is a fundamental right. It's essential to a fair trial, and they made it obligatory upon the states through the 14th Amendment.
So if you are charged with a felony and cannot afford a lawyer, the state simply must provide one.
Exactly.
Well, that sounds like a massive triumph for equal protection. The system worked.
I mean, in theory, it was a triumph. Gideon established the baseline.
Right.
But here's the catch. The Supreme Court didn't say how those lawyers should be funded or what standards they had to meet.
Of course.
It actually took until 1984, in a case called Strickland v. Washington, for the court to define what effective counsel actually means.
And how did they define it?
In Strickland, the court created a highly differential standard. They ruled that to prove a lawyer was ineffective, a defendant has to show that the lawyer's performance fell below an objective standard of reasonableness.
Okay.
And they have to prove that this poor performance actually prejudiced the outcome of the case.
Which, again, sounds reasonable if you don't really know how courts work. But what does that actually mean in practice?
In practice, it set the bar for competence incredibly low.
How low?
The court essentially said judges shouldn't second-guess the tactical judgments of lawyers in hindsight. So over the decades, appellate courts have literally upheld convictions where public defenders were drunk, high, or literally sleeping during the trial.
Wait, really? Sleeping?
Yes, because under Strickland, the defendant has to prove that the lawyer being asleep actually changed the outcome of the verdict.
Which is almost impossible to prove.
Exactly. How do you prove what a sleeping lawyer missed?
So Gideon guarantees you a lawyer, but Strickland basically guarantees that the lawyer barely has to have a pulse.
That's the reality. And Enfield contrasts this weak doctrinal floor with the terrifying operational reality on the ground today.
The data on this is just staggering.
It is. He cites the American Bar Association's 2023 National Public Defense Workload Study. To understand the collapse of equal protection, we really have to do the math on these numbers.
Let's do the math. Walk us through the ABA data.
So the ABA brought in experts, data scientists, and veteran defense attorneys to analyze how much time is actually required to provide constitutional competent representation.
Right, for a felony.
Right. They looked at everything. Reading police reports, watching body cam footage, interviewing witnesses, negotiating with prosecutors, preparing for trial, communicating with the client.
Everything a real defense requires.
Exactly. And based on that rigorous analysis, the ABA study recommends that a public defender should handle a maximum of about 59 felony cases a year.
Okay, 59 felonies a year. That gives a lawyer roughly about a week per case, assuming they work standard hours.
Yes.
Which seems entirely necessary if someone's actual life and liberty are on the line.
It absolutely is. But Enfield points out the reality. In many jurisdictions across America right now, Public defenders are carrying caseloads that approach or even exceed 500 felony cases a year.
500 cases. Wait, let's do the brutal math on that.
Let's do.
If a lawyer works 2,000 hours a year, which is what, 40 hours a week, 50 weeks a year, assuming no sick days, no vacations.
Yeah, 2,000 hours.
And they have 500 cases. You divide 2,000 by 500. That means they have exactly 4 hours to dedicate to each case.
4 hours.
4 hours total, from the arraignment to the sentencing.
4 hours to watch the body cam footage, which might be 3 hours long by itself.
Wow.
4 hours to read the forensic reports. 4 hours to track down the alibi witness. 4 hours to explain the law to a terrified defendant is a physical impossibility.
It's just processing paper at that point.
Exactly. And Enfield is very clear about something here. The public defender is not the enemy in this essay.
No, of course not.
Most public defenders are incredibly dedicated, overworked public servants doing their absolute best in a broken system. The problem is the structure.
Right. The system starves them of resources, time, and investigators.
Yes. The gap between the ABA's standard of 59 cases and the reality of 500 cases is the exact gap where equal protection completely falls apart.
Private defense is a market where the wealthy can just buy endless time, endless experts, private investigators.
But public defense is a starvation budget.
Yeah. And while the overwhelmed public defender is trying to juggle those 500 cases in their tiny 4-hour windows, where is the defendant?
That's the real question.
They usually aren't sitting at home waiting for the phone to ring. They are sitting in a county jail cell because the next gear in the machine is pretrial detention and cash bail.
Right.
And Enfield makes a profound philosophical point here. If freedom depends on money, then poverty becomes a punishment before conviction.
It's undeniable. If I have $1 million and I'm accused of a crime, I pay my bail, I go home, I sleep in my own bed, I go to work, and I help my lawyer build my defense over the next year.
Right.
But if I have $50 and I'm accused of the exact same crime, I am locked in a concrete box, separated from my family, for months or even years, just waiting for trial, and I am legally innocent the entire time.
The statistics bear out the massive scale of this, too. According to Bureau of Justice Statistics data from mid-year 2024, 69% of the local jail population in America is unconvicted.
69%. Let that sink in.
Nearly 7 out of 10 people in local jails have not been found guilty of the crime they are locked up for.
They are legally innocent people waiting court action. And Enfield argues forcefully that jail is not just a neutral waiting room.
No, it is an active instrument of destruction. I mean, even a few days in jail can completely derail a life.
Oh, absolutely.
You lose your job because you didn't show up. If you lose your job, you can't pay your rent, so you lose your housing.
You lose your car.
You lose your car. If you are a single parent, you could lose custody of your children. Your mental stability is wrecked. The jail cell is applying massive existential pressure on the defendant every single second of the day.
And it fundamentally alters the legal case itself. We have this myth in America, popularized by television, of the dramatic jury trial, right?
Right, the prosecutor and the defense attorney arguing before a jury of 12 peers.
Right, but the empirical reality of American justice is not the jury trial. It is the plea bargain.
Yep.
The United States Department of Justice reports that approximately 95% of state and federal felony convictions are obtained through guilty pleas.
95%.
95%. The jury trial is statistically dead.
So the entire system is really just an administrative processing pipeline designed to extract pleas.
Yes, it is. And the National Bureau of Economic Research, along with the Vera Institute, have published extensive peer-reviewed data showing that pretrial detention significantly increases the probability of conviction.
And why is that?
Primarily because it induces guilty pleas. Detained defendants are far more likely to plead guilty than similarly situated defendants who were released on bail.
Yeah, because they just want to get out.
Exactly.
If you are sitting in a dangerous, overcrowded, violent county jail, you've lost your job, your kids are in state custody, and the prosecutor walks in and says, look, plead guilty today and you get out with time served and probation, or fight it, wait for a trial, and sit in this cell for another 8 months.
It's not a choice.
The pressure is unimaginable. You aren't making a free constitutional choice about the factual evidence of your case. You are making a survival choice about the cage.
Exactly. You are pleading guilty to escape the process, not because the state proved its case beyond a reasonable doubt.
Wow.
Now, if you challenge this system, the doctrinal rebuttal from the government is usually the 1987 case, United States v. Salerno.
Okay, what happened in Salerno?
In Salerno, the Supreme Court upheld the constitutionality of the Bail Reform Act. This allowed federal courts to detain arrestees prior to trial if they were deemed a danger to the community.
So the defender of cash bail will argue that money bond has a long Anglo-American tradition to just ensure a defendant simply appears in court.
Right.
I'll play devil's advocate here. Isn't that the point? If we let everyone out for free, no one comes back to court. Bail is just collateral to ensure you show up to your hearing.
And that's the standard defense.
Yeah.
But Enfield counters this by pointing to a completely different line of Supreme Court cases. He
Yeah.
looks at wealth-based detention cases post-conviction.
Post-conviction.
He cites cases like Williams v. Illinois, Tate v. Short, and Bearden v. Georgia.
What happened in those?
In those cases, the Supreme Court looked at systems where a person was convicted and ordered to pay a fine. If they couldn't pay the fine, they were sent to prison to basically work off the debt.
A debtor's prison.
Exactly. And the Supreme Court struck those systems down. They held that you cannot imprison someone solely because of their indigency, their inability to pay a fine. It violates equal protection to have a debtor's prison.
So Enfield is saying, take the logic of Bearden, that you can't lock someone up just because they are poor after they are convicted, and apply it to cash bail before they are convicted.
Precisely. If wealth-based detention is constitutionally suspect post-conviction, when the state has already proved guilt, Enfield argues it should be glaringly unconstitutional pre-conviction.
When the person retains the presumption of innocence?
Right. Because cash bail structurally traps the poor while letting the wealthy go home to build their defense. And this leads to Enfield's synthesis of this entire section.
Which is?
What's fascinating here is the instrumental nature of the right to counsel.
What does he mean by instrumental?
Gideon didn't just give you a lawyer so you could have a friend in the courtroom.
Yep.
The right to counsel was intended to be instrumental. It is the shield that allows you to exercise your other rights. A lawyer allows you to confront witnesses, to file motions against illegal searches, to demand a jury trial.
But if the shield is made of paper because of a lack of funding, I mean, remember the 4 hours per case, and you are locked in a cage because of a lack of wealth, the rights that paper shield supposedly protects just completely evaporate.
They're gone. The lawyer can't save you from the pressure of the cage.
Okay, so the public defender doesn't have time, and the jail cell is actively breaking the defendant's will. But a cage doesn't force a guilty plea on its own.
No, it doesn't.
The jail cell is passive. Someone has to walk up to the bars and actually make the offer. Someone has to decide the stakes, which means we need to look at the person holding the keys to that leverage, the prosecutor.
And the prosecutor is arguably the single most powerful, unchecked actor in the entire American criminal justice machine.
Seriously.
More than the judge.
Oh, definitely. They hold almost absolute discretion over screening cases, deciding what charges to file, what plea offers to make, what cases to dismiss, and what enhancements to seek.
I think the general public has this misconception that the law is just automatic. Like, if you steal a car, the law says Grand Theft Auto, and the prosecutor just processes that specific charge.
The reality is completely different. The criminal code is incredibly vast and overlapping. A single act can often be charged in 5 different ways.
Right.
Prosecutors choose among a menu of statutes, mandatory minimums, and sentencing enhancements. And Enfield focuses heavily on how this massive discretion is weaponized into what he calls charge stacking, to create what is known as a trial penalty.
And to illustrate this, Enfield brings up a Supreme Court case study from the text that, honestly, when I read it, it left me completely speechless. Bordenkircher v. Hayes from 1978.
It is a shocking case.
I want you to walk me through the timeline of this case, because when I read it, I literally couldn't believe it was real. Okay, take the case of Paul Hayes. In the 1970s in Kentucky, Hayes was accused of forging a check.
Okay, forging a check. White-collar crime, nonviolent, maybe a few months probation, some restitution.
Well, the check was for exactly $88.30.
Wow.
And under Kentucky law at the time, forging a check was an offense carrying a penalty of 2 to 10 years in prison. So the state prosecutor sits down with Hayes and his lawyer and offers him a plea deal.
Okay.
The prosecutor says, plead guilty, save us the time of a trial, and I will recommend a 5-year sentence.
5 years for an $88 check is already incredibly harsh, but okay, that's the offer.
But then the prosecutor adds a threat. He tells Hayes, if you refuse this plea offer and insist on exercising your constitutional right to a trial, I'm going to return to the grand jury and re-indict you under the state's habitual criminal act.
Oh, boy.
Hayes had 2 prior felony convictions on his record. And under that act, if you were convicted at trial as a habitual offender, the sentence is mandatory life in prison.
Wait.
Right.
Life in prison for an $88 check.
Yeah.
How is that not a typo in the constitutional record? The prosecutor is literally saying, take 5 years or I will lock you in a cage until you die. Over $88. So what did Hayes actually do?
Hayes refused the plea. He believed he had a right to a trial.
Right, it's the Constitution.
So he goes to trial. The prosecutor follows through on the explicit threat, returns to the grand jury, gets the habitual offender indictment, and Hayes is convicted. And just as threatened, he is sentenced to mandatory life in prison.
That's insane.
Hayes appeals this all the way to the United States Supreme Court, arguing that this was vindictive prosecution. He argued he was being punished with a life sentence purely for exercising his right to a trial.
And the Supreme Court said what? They threw it out, right?
No, they upheld the life sentence.
You've got to be kidding me.
In a 5-4 majority opinion written by Justice Potter Stewart, the court held that the Due Process Clause of the 14th Amendment is not violated when a prosecutor carries out a threat made during plea negotiations to re-indict the accused on more serious charges if he does not plead guilty.
I am genuinely struggling to see how this is legally, let alone morally, permissible.
The majority reasoned that plea bargaining flows from a mutuality of advantage. They said the system depends on plea bargains, and there is no element of unconstitutional punishment or retaliation as long as the accused is legally free to accept or reject the prosecutor's offer.
Free to accept or reject. 5 years versus life in prison. It's like a doctor saying, take this pill and you'll be sick for a year, but if you ask for a second opinion, I'm legally allowed to amputate your legs.
Exactly.
That's not a medical choice. That's a hostage situation. I mean, if a store offers you a TV for $500, but says if you ask for a receipt, they will charge you $5,000, that's extortion. But when the state does it with your actual life and liberty, it's just called leverage.
And that is the exact outrage that the dissenting justices voiced. Enfield points us directly to the dissents by Justice Harry Blackmun and Justice Lewis Powell in Bordenkircher.
What do they say?
Justice Blackmun argued that the prosecutor's threat was purely retaliatory. He pointed out that the prosecutor had all the information about Hayes' prior record when he originally offered the 5-year plea.
Right. No new evidence actually emerged.
Right. The prosecutor's own initial assessment was that 5 years was the appropriate punishment for the crime. So the leap from 5 years to life in prison was solely, unequivocally, a punishment for Hayes exercising his constitutional right to a jury trial.
And what did Justice Powell say?
Powell agreed. He argued that allowing prosecutors to threaten defendants with vastly disproportionate sentences completely denies the defendant any actual benefit from the bargaining process. It specifically targets the defendant with a trial penalty.
A trial penalty?
Right. Powell basically asked, if a prosecutor can threaten life in prison over an $88 check just to avoid a trial, where is the limit on prosecutorial power?
The trial penalty. That is the core of this entire section, really.
Yes, and Bordenkircher is the foundational doctrinal bedrock that makes the trial penalty legal in America today. Enfield cites a 2018 comprehensive report by the National Association of Criminal Defense Lawyers. They documented that federal defendants who exercise their right to go to trial receive sentences on average 3 to 7 times longer than those who plead guilty to the exact same conduct.
3 to 7 times longer. So if you plead guilty, you get 2 years. If you ask for a trial, you get 14 years for the same exact crime.
The trial penalty is the structural backbone of the modern justice system. The state uses enhanced statutory exposure as bargaining pressure, forces the defendant into an impossible corner, and then when the defendant breaks and signs the plea agreement, the state calls the surrender voluntary.
Unbelievable.
The paperwork looks clean, the docket is processed, but the protection is non-existent.
It's just redefining coercion. So the public defender is overwhelmed, the prosecutor applies massive pressure, the jail cell amplifies the pressure. But what about the person who oversees the whole process?
The judge.
Right, the person in the black robe sitting above it all. We need to look at the judges and the unseen forces in the courtroom that Enfield says dictate their behavior.
The foundational assumption of the justice system is that the judge is a neutral, independent arbiter. Blind justice, right?
Right.
But Enfield argues that equal protection is fundamentally fragmented by geography and politics. When you walk into a courtroom, you are not just facing the abstract concept of the law. You are facing a specific human being with specific political pressures in a specific county.
How does Enfield actually prove this geographic fragmentation?
He cites a 2012 report from the United States Sentencing Commission. Now, the federal system is supposed to be the most procedurally standardized system in the country. They have explicit numerical sentencing guidelines, like a grid.
To keep things uniform.
Exactly. Yet the Commission's data found persistent, statistically significant variation in sentence lengths within the exact same courthouse, depending purely on which judge happened to be randomly assigned the case.
So your fate, the number of years you spend in a cage, is decided by the random spin of a bureaucratic judicial wheel. You get Judge A, you go home in a year. You get Judge B, you serve 10 years.
Exactly. And Enfield notes that if this level of arbitrary variation exists in the highly regulated federal system, it is vastly worse at the state and county levels.
I can imagine.
But the fragmentation isn't just geographic, it's deeply structurally political. And this is where Enfield brings in heavily researched data from the Brennan Center for Justice, specifically reports titled Skewed Justice and Bankrolling the Bench.
Right, because unlike federal judges who are appointed for life, state judges are often elected by the public. They actually have to run campaigns.
Yes. 39 states use some form of election to choose at least some of their judges. The Brennan Center analyzed thousands of criminal appeals decided by state Supreme Courts over several years.
And what did they find?
What they found is chilling. They found a statistically significant correlation between the volume of television advertising in judicial elections and the rate at which state Supreme Court justices ruled against criminal defendants.
Wait, let me make sure I understand that. The more political ads run on TV, the harsher the judges become in the courtroom.
Precisely. Let that sink in. In political environments saturated with tough on-crime campaign ads, especially in the era post-Citizens United, which opened the floodgates to unlimited independent corporate and dark money expenditures, judges facing retention elections fundamentally change their voting behavior.
That's terrifying.
The data shows they vote against criminal defendants more often as Election Day approaches, and in states with higher ad spending.
You know, here's where it gets really interesting. That completely changes how I think about judicial independence.
Right.
If a judge is altering their legal rulings based on the volume of campaign ad spending in their state, then the defendant's sentence has absolutely nothing to do with their actual crime or the law or justice.
Well,
The sentence is based on the judge's fear of a primary challenger. The defendant is no longer a human being adjudicated. They have literally become political material, a prop to avoid a negative campaign commercial.
now, I want you to play the devil's advocate again here, because Enfield directly addresses the strongest counter-argument to this geographic and local variation. The defender of the American system will point to federalism and the 10th Amendment.
Okay, I'll play the states' rights advocate. The Constitution was designed to give states power.
Right.
If the voters of Texas want to elect tough-on-crime judges and have harsh laws, and the voters of Vermont want lenient judges and rehabilitative laws, why can't they? That's the design of the republic. Variation is a feature, not a bug. If you don't like the laws in Texas, move.
And it is a strong, historically grounded argument. But Enfield dismantles this by drawing a crucial, razor-sharp distinction between policy and architecture.
What's the distinction?
He agrees that federalism protects substantive policy choices. A state legislature can absolutely decide what conduct is a crime and what the baseline penalty should be.
So Texas can say stealing a car is 10 years, Vermont can say it's 2 years?
That is federalism. But, Enfield argues, the 14th Amendment demands a national floor for protective architecture.
Protective architecture. What is the difference between substantive policy and protective architecture?
Different states can criminalize different things, but they cannot provide radically different defensive structures to citizens facing the wrath of the state.
Okay, I'm following.
A state cannot offer a fully funded public defender office to one county and a starved 500-case-a-year office to another. A state cannot have a bond system that lets rich people buy their freedom in one city while poor people rot in jail for the same crime in another.
Right.
A state cannot subject its citizens to judges who change their rulings based on dark money TV ads. Federalism allows states to write the law, but the 14th Amendment requires the defense against that law to be equally robust everywhere.
That is a brilliant distinction. It's the difference between what the law is and how fairly you are permitted to defend yourself against it.
Exactly.
And Enfield points out that this unequal architecture isn't just the high-profile stuff like judges and prosecutors. It goes all the way down to the invisible bureaucracy of clerks and court administrators, right?
It does. The clerk system controls the entire paper trail, fee schedules, access to transcripts, procedural navigation.
Right.
If you are a wealthy defendant with a private law firm, paralegals and junior associates handle all of this. They navigate the bureaucracy. But for a poor defendant, perhaps representing themselves or dealing with a public defender who has 4 hours for their case, a complex fee schedule to print a document, or a confusing procedural rule to access their own evidentiary records becomes an insurmountable barrier.
Just a wall of bureaucracy.
Right. The system fractures equal protection in 1,000 invisible bureaucratic ways that never make the headlines.
So let's take a breath and look at where we are.
It's a lot.
We have a system where you are pressured by a terrifying, destabilizing jail cell. You are leveraged by a prosecutor threatening a mandatory life sentence over an $88 check. You are represented by a lawyer who hasn't had time to read your file. You are judged by politically vulnerable actors terrified of TV commercials.
Yep.
And your ability to navigate the building is blocked by fees. And if you succumb to all that structural pressure and take the plea deal just to escape, what does that leave you with?
A record.
A criminal record, a felony conviction. But as Enfield argues, that record is not what society thinks it is. Let's talk about what he calls the record multiplier.
This is perhaps Enfield's most radical, paradigm-shifting doctrinal critique. It concerns the doctrine of recidivism and prior record enhancements.
Okay.
To understand this, we need to look at how the Supreme Court currently treats prior convictions. Let's start with a 1998 case called Almendez-Torres v. United States.
Okay, set the constitutional stage for this. The Fifth and Sixth Amendments guarantee the right to a jury trial, right? Juries are supposed to decide the facts that lead to punishment.
Exactly. Juries decide facts, judges apply sentences based on those facts. But in Almendez-Torres, the Supreme Court created a massive exception.
What was the exception?
They ruled that the bare fact of a prior conviction can be used by a judge to enhance a defendant's sentence without needing to be proven to a jury beyond a reasonable doubt in the current trial.
Wait, really?
Yeah. The court said a prior record is merely a sentencing factor, not an element of the new crime.
So the judge can just look at a piece of paper and arbitrarily increase the punishment, bypassing the jury entirely.
Yes. And the court solidified this in later cases, like Apprendi v. New Jersey. In Apprendi, the court laid down a strict rule. Any fact that increases the penalty for a crime beyond the prescribed statutory maximum must be submitted to a jury and proved beyond a reasonable doubt.
Which sounds good.
But they explicitly carved out and maintained the Almendez-Torres exception for prior convictions. The prior record is the golden exception of the jury requirement.
And what does this look like in practice when someone is actually sentenced?
It leads to cases like Ewing v. California in 2003. Gary Ewing walked into a pro shop in California and stole 3 golf clubs valued at $399. A petty theft. But Ewing had prior felony convictions on his record. Because of California's 3 strikes law, the prosecutor used his prior record to enhance the charge.
Oh, no.
Ewing was sentenced to 25 years to life in prison.
25 years to life for stealing $400 worth of golf clubs. Because he had a piece of paper in his file.
Because of his prior record. Ewing appealed, arguing this was cruel and unusual punishment under the Eighth Amendment, but the Supreme Court upheld the sentence.
That's heartbreaking.
Under current legal doctrine, the law treats a prior conviction as a perfectly neutral, objective data point. It's an undisputed fact. You plug it into a sentencing grid, and the punishment mathematically increases. But this is where Enfield introduced the concept of the record multiplier.
What exactly is the record multiplier?
Enfield argues that a criminal record is not a neutral, sterile data point. It is the historical residue of an unexamined, profoundly unequal process.
Walk me through this logic, because this challenges the fundamental way society views repeat offenders.
Imagine the first time a defendant, let's call him John, was processed by the system. John was poor. He was trapped in a county jail because he couldn't afford $500 for bail. Okay.
Setting the scene.
He lost his job. His public defender had 500 cases and spoke to him for maybe 10 minutes. The prosecutor threatened to stack charges and send him away for 10 years if he went to trial.
All the structural pressures we just talked about.
Exactly. Under all that structural pressure, John broke and pled guilty to a felony just to get out on probation. The system records that as a conviction. The paperwork is filed.
The procedural skeleton is completed.
Exactly. Now, 5 years later, John is arrested again for a low-level offense. The state points to that first conviction and says, aha, you are a repeat offender. You are a career criminal. Because of this prior record, you now face a mandatory minimum sentence, and we are doubling your statutory exposure from 2 years to 10 years.
The record multiplier. The inequality just compounds itself.
Exactly. If the first conviction was the product of unequal protection, wealth-based detention, starved defense counsel, coercive plea leverage, Using that record to mandate a harsher sentence later means the state is manufacturing a record through an unequal process and then using that very manufactured record to justify more unequal protection later.
The inequality compounds itself through the mechanism of the law.
Yes, the state is laundering its own unconstitutional behavior through a piece of paper.
You know, I am going to push back hard here because I think a lot of listeners will hear this and think it sounds like an excuse for crime.
That's a fair reaction.
Like, don't we want repeat offenders off the street? Isn't past behavior the absolute best predictor of future risk? If a guy keeps robbing stores, society demands that the system incapacitate him. How can Enfield say we should just ignore a criminal record?
That is the exact tension Enfield is navigating. And he is proposing a very specific, nuanced legal solution. He calls it the first offense equality rule.
How does the first offense equality rule actually work?
The rule demands that the state must charge, defend, and structurally sentence every new charge as if it were the first offense.
Okay.
The core constitutional idea is that equal protection means the exact same present act must carry the exact same legal weight at the starting line. The state cannot create two fundamentally different versions of the same offense, like a standard version for a first-time offender and a supercharged mandatory minimum version for someone based on their status as a repeat offender.
But wait, didn't you just say he isn't saying we should ignore the record completely?
Correct. The text explicitly clarifies this. The state can use a prior record for individualized discretionary sentencing within a normal standard statutory range.
So how would that work?
The state can also use it to determine conditions for probation or parole. For example, if the law says the crime of burglary carries a range of 2 to 5 years, a first-time offender might get 2 years. The judge can look at Jaw's prior record and say, "You've been here before, I am giving you the maximum 5 years."
Oh, I see.
That is individualized sentencing within the standard range.
Okay, so the judge can still punish them harsher within the normal box. What is the state not allowed to do?
The state cannot use the record to fundamentally rewrite the statutory exposure itself. The state cannot say, because of your record, the box is no longer 2 to 5 years. The new box is a mandatory 20 years to life.
Wow. Okay.
Enfield writes a phrase that perfectly captures this. He says, the state may prosecute the act. It may not enhance the person.
The state may prosecute the act. It may not enhance the person.
Exactly. The law shouldn't transform a defendant into a different legal caste, stripped of standard protections, just because of historical paperwork.
That is an incredibly powerful legal philosophy because when the state rewrites the statutory exposure, when they change the 5 years to 20 years, they're increasing the prosecutor's leverage all over again.
Precisely.
They're restarting the trial penalty machine, but with even heavier weights. They're using the threat of the 20 years to force another guilty plea, generating another conviction, and the cycle just continues until the person is buried alive in prison.
And if we look at the legal foundation for these prior record enhancements, it is remarkably fragile. Enfield notes that the controlling case, Almendarez-Torres, was a 5-4 decision.
So a very divided court.
Very divided. And Justice Clarence Thomas provided the crucial fifth vote to establish the prior record exception. But Justice Thomas has since publicly, in written opinions, disavowed his own vote in that case.
Wait, really?
Yes. He has stated he was wrong and has repeatedly called for the Supreme Court to overrule Almendarez-Torres.
So the very justice who created the majority says it was a mistake. Why is it still the law?
The doctrine is held in place almost entirely by stare decisis.
Stare decisis.
Yeah, the legal principle of respecting precedent and not overturning past decisions lightly. The court is hesitant to disrupt thousands of sentences, but Enfield argues that stare decisis is not a suicide pact.
Right.
It does not turn a constitutionally questionable, structurally unequal doctrine into a morally adequate one. A doctrine can be settled law, supported by precedent, and still be fundamentally wrong.
Okay, we have been incredibly deep in the weeds of the criminal justice system itself.
Very deep.
We've looked at the machinery of the courtroom, the jail, the prosecutor's office, the public defender's workload, and the judge's campaign ads. We've looked at the compounding math of the record multiplier.
Right.
But Enfield doesn't stop at the courthouse doors. He makes a massive leap here. He argues that this unequal machinery of justice actually begins much, much further upstream, before a crime is even committed, before a defendant ever meets a lawyer.
This is where the essay shifts from criminal procedure into grand constitutional architecture. We are entering the section titled, When the Law Itself is Not Equally Protected.
Okay.
Enfield moves his focus from the 14th Amendment's Equal Protection Clause to Article 1 of the Constitution, and he focuses a massive critical spotlight on the 17th Amendment and the United States Senate.
Now, if you're listening to this on your commute right now, you might be thinking, wait a minute, I tuned in to hear about criminal justice. Why do I care how United States senators were elected in 1913? I'm worried about crime today.
It's a fair question.
What does the Senate have to do with a poor defendant sitting in a county jail?
It has everything to do with it, because of the laws that build the jail.
Tell me more.
Enfield argues that before a person is ever charged with a crime, the law has already been written. The penalties and mandatory minimums have been structured. The federal funding for public defense has been authorized or denied.
Right, the board is already set.
Exactly. The lawmakers who write that entire system enter power through a specific constitutional gate. If that gate is captured, distorted, or bought, then the laws it produces are structurally unequal from the moment they are drafted.
Okay, I follow that.
And Enfield traces this massive structural distortion directly to the 17th Amendment, which was ratified in 1913.
Let's do a quick civics refresher. Before 1913, under the original Article 1, Section 3 of the Constitution, United States senators were not elected by the public. They were chosen by the state legislatures.
Precisely. The original text of the Constitution said senators were chosen by the legislature thereof. Enfield does a very deep, originalist textual analysis here.
What does he find?
He points out that the founders designed a bicameral legislature with two very different bodies. The House of Representatives was meant to represent the passions of the mass public elected directly by the people every 2 years.
Right.
But the Senate was designed to represent the institutional power of the state itself.
So the senator was essentially an ambassador from the state government to the federal government.
Yes. The state legislature was the constitutional gate. The senator was a United States senator chosen for a state. The state legislature was the channel, but the office was federal.
That makes sense.
Because they were appointed by the legislature, senators didn't have to run mass public campaigns. They didn't have to raise millions of dollars in the general public. They answered to the state house. The senator was not meant to be an inhabitant of the state's mass political campaign machinery.
But then the 17th Amendment fundamentally changes the gate. It rewrites Article 1. It says, senators are now elected by the people thereof. Direct popular election.
Yes.
Which, to a modern ear, sounds like a great necessary democratic reform. We love democracy. We all vote for our senators now. So what is Enfield's structural objection to this? Why does he think giving people the vote broke the system?
His objection relies on Article V of the Constitution, which is the article that outlines the rules for how the Constitution can be amended.
Okay.
Article V has a specific, highly unusual, unamendable clause at the very end of it. It says, no state, without its consent, shall be deprived of its equal suffrage in the Senate.
So you can amend almost anything else, but you cannot touch equal suffrage in the Senate.
Exactly. Now, the official, settled legal doctrine today says the 17th Amendment is perfectly valid because every state still has 2 seats and each senator still has 1 vote. The arithmetic is exactly the same, so equal suffrage is preserved.
So the doctrine says equal suffrage just means the math. 2 equals 2. As long as Wyoming has 2 and California has 2, the Constitution is satisfied.
Exactly. But Enfield argues this reduces the profound concept of equal suffrage to a mere arithmetic shell.
What's his interpretation?
He argues that the original design gave the state a specific mode of participation, the state legislature's constitutional hand actively picking the senator.
Suffrage isn't just having a chair, it's the right to decide who sits in it.
Exactly. By removing that institutional hand and replacing it with a mass popular election, the 17th Amendment preserved the 2 chairs, but it removed the state's structural key to those chairs.
I see.
He argues Article V cannot be used to hollow out the protective institutional architecture of the Senate while pretending nothing essential has changed.
So what does this all mean? Let me try to ground this with an analogy because this is heavy constitutional theory.
Please do.
It's like if a major corporation had a rule that its board of directors, which represents the state legislature in this scenario, had the exclusive power to appoint the CEO, the senator.
Right.
But suddenly, a new corporate rule is passed saying the CEO will now be chosen by a mass popularity contest among millions of consumers funded by outside advertising agencies.
The title on the door still says CEO.
Exactly. The math is the same. There is one CEO. But the loyalty, the incentives, the accountability, and the entire path to power have been fundamentally, permanently altered. The CEO no longer answers to the board. They answer to whoever bought the most ads.
That is a perfect structural translation of Enfield's argument. By changing who elects the Senate, you fundamentally change what the Senate is. You change the accountability structure.
That makes total sense.
And this leads us directly to Enfield's grand synthesis regarding what he calls campaign market capture.
Campaign market capture.
Yes. When you move Senate selection from a deliberative institutional body, the state legislature, to a statewide political electorate, you move the gate into the United States Senate into the mass campaign marketplace.
Because the state electorate is a mass field of millions of people, and a mass field requires marketing to reach them.
Exactly. And mass marketing requires astronomical amounts of money. Enfield connects this shift directly to modern campaign finance doctrines. He looks at landmark Supreme Court cases like Buckley v. Valeo from 1976.
Explain Buckley v. Valeo.
In Buckley, the Supreme Court struck down limits on campaign expenditures, essentially ruling that spending money to influence elections is a form of constitutionally protected free speech.
Okay.
If you restrict a candidate's ability to spend money to buy ads, you are restricting their speech. And Enfield pairs this with the infamous 2010 case, Citizens United.
Right, which ruled that the government cannot restrict independent political expenditures by corporations, labor unions, and wealthy individuals.
Exactly. Money equals speech, and corporations have speech rights. That opened the floodgates to billion-dollar Senate races.
So we have a system flooded with cash.
Right. Now, Enfield points out a glaring structural paradox in the law. Direct vote buying, standing outside a polling place and handing a voter a $100 bill for their ballot, is a severe federal felony.
Right, obviously. It is strictly illegal to buy the hand that casts the vote.
But campaign finance is constitutionally protected.
Oh.
Precisely. You cannot buy the hand, but the Supreme Court has protected the ability of massive wealth to buy the atmosphere around the mind.
Buying the atmosphere around the mind, that's a great way to phrase it.
You can spend hundreds of millions of dollars saturating the airwaves with fear narratives, algorithmic data manipulation, party machine branding, and targeted outrage.
Yeah.
Enfield's argument is that a mass state electorate can be marketed to and manipulated by wealth. Therefore, the federal office of the senator, which relies on that mass election, becomes a captured instrument of the state campaign market.
I see the downstream connection now. This is how the Senate connects to the jail cell.
It all flows downstream.
Think about it. If you are listening to this, the political ads you see on your phone right now, funded by dark money PACs, are literally the funding mechanism that buys the lawmakers. The politician writes the criminal code before the judge ever opens the file. The Senate confirms the federal judges. They fund the law enforcement grants. They structure the mandatory minimums that the prosecutor uses to threaten Paul Hayes with life in prison.
It's all connected.
If the lawmaker bought their way into the room through an unequal, money-drenched marketplace, the laws they write are inherently shaped by that inequality. The cage was built with unequal steel.
This is exactly how Enfield elegantly bridges the two halves of his essay. The captured upstream Senate creates the downstream reality of the courthouse. The people are prosecuted under laws produced by a structurally distorted lawmaking channel.
It's a complete cycle.
Now, to encourage critical thinking here, Enfield is very careful to acknowledge the messy reality of history. He isn't claiming that 19th century state legislatures were perfectly pure, incorruptible bodies of high-minded statesmen.
Right, because state legislatures could absolutely be bought off, too. The Gilded Age was famous for railroad barons essentially buying state senators.
Yes, and Enfield explicitly acknowledges the historical scandals, like the Lorimer bribery scandal in Illinois, which fueled the populist outrage that led to the 17th Amendment.
Oh, yeah. William Lorimer literally bribed state legislators to secure his U.S. Senate seat.
He did. So if the old system was corrupt, why is Enfield criticizing the reform?
Good question.
Because his point is structural. He's saying that replacing one form of illegal, localized corruption, bribing a legislature, with a legalized mass market influence machine, while pretending the constitutional structure is unchanged, means the law itself is bent upstream.
The remedy to the old problem created a new, vast, constitutionally protected path for mass electoral capture.
Exactly. And because the law is bent upstream in the Senate, the people are processed downstream in the courthouse by an unequal machine that is wearing the language of justice. As Enfield writes, unequally protected law creates unequally protected people.
Wow. Let's pull all of this together because we have covered immense ground today.
We really have.
This essay takes us on an incredible journey that starts with the individual, terrified defendant. We looked at the overworked public defender drowning in 500 cases a year, trying to provide constitutional representation in 4-hour windows.
Right.
We examined the brutal, coercive pressures of cash bail and pretrial detention, where freedom depends on wealth and the cage actively forces guilty pleas. We unpacked the terrifying leverage of the prosecutor's trial penalty, using the threat of life sentences to extort surrender.
The Borden-Kircher case.
We saw how a prior record becomes a mathematical multiplier, manufacturing compounding inequality. We saw how state judges change their legal rulings based on the fear of dark money television ads.
And we traced it all the way up.
Right, we traced all of those downstream effects all the way upstream to a captured federal legislature where the lawmakers themselves are the products of an unequal, multi-billion-dollar campaign marketplace.
The system constantly demands that the defendant take ultimate responsibility for their actions. But Enfield is demanding that the system take responsibility for its own architecture.
Exactly. He is asking us to stop looking at the procedural paperwork, the signed plea deal, the assigned lawyer, as absolute proof of justice.
He is demanding we start examining the machinery that produced the paperwork. And that brings up a final, highly provocative thought for you, the listener, to consider. One that builds on Enfield's work, but extends it out into our daily civilian lives.
Go for it. Leave us with something to chew on.
If we accept Enfield's premise that a criminal record is often just the historical residue of an unexamined, fundamentally unequal process of pressure and coercion, what does that mean for society outside the courtroom?
Think about the everyday corporate world.
When an employer tosses a resume into the trash, or a landlord denies an apartment application based on a routine $15 online background check, what is actually happening?
We think we are just doing due diligence, keeping our community safe.
Right. But if Enfield is correct, are everyday citizens, HR departments, and property managers functioning as the final, unwitting enforcers of this unequal constitutional machine? Are we, as a private society, continuously punishing people, denying them housing, and starving them of livelihood based on paperwork that only proves they were processed by an unequal system rather than protected by a fair one? When we demand a clean background check, are we just demanding proof that someone survived the collapsing mine?
That is a haunting thought to end on. If the paperwork is unequal, then the society relying on it is just enforcing the inequality. We've gone from the X-ray machine to the collapsing mine to the boardroom and now all the way to the HR desk. Thank you so much for joining us on this deep dive. Keep questioning the structures around you, look past the procedural paperwork, and we'll see you next time.